Good evening, everyone, and welcome to the ninth installment of Operation Safe Spaces Family Law Seminar. This evening, our presenter is Attorney at Law and Principal Crown Counsel, Krystal Delaney, who will be taking us through tonight's topic, Litigating Sexual Offences in Barbados. Just a couple of quick housekeeping notes before we begin. Tonight's session is again designed to be an interactive one. And Krystal has designed a number of polls that will be introduced throughout the session. And as with last week, we encourage you to use the reaction button and raise your hand or unmute your mic and jump in with any questions or comments as the session progresses. Again, the session is being recorded, and if you haven't already done so, we would really appreciate if you could complete the consent form and return, and you'll find the link for that in the 30-minute meeting reminder that just went out a few minutes ago. As always, please check us out on our social media pages on IG or Facebook at oss.246. And again, on Thursday, we will have our little switch up. So on Thursday, we'll have the international perspective on high conflict divorce and separation with Lisa Johnson and Chris Barry from Been There, Got Out from the United States. And then our final topic will be on Tuesday next week, September 7th, which is Barbadian case studies in family law matters. So without further ado, I will hand everything over to Krystal and we can go ahead and get started.
Thank you. Good evening, everybody. As Robin said, feel free to stop me at any point in time to ask questions or make comments. Right. So the first step in the process I'm going to discuss is initiating the proceedings. It's normally initiated by a complaint made to the police officers. If it's a minor, the complaint will be made on behalf of a parent or the child care board if the complaint is against one of the parents. And the police would then conduct interviews and a medical examination, which will be conducted by the public medical officer most of the time. In relation to the interview is normally conducted on the day of the report by a police officer, where the complainant is asked about the incident that he or she is complaining of. In relation to children, when a complaint is made and the complainant is a young child, the interview is sometimes carried out at the child care board in a special room that they have down there that's outfitted with toys and that kind of thing. And the police officer can conduct the interview there in the presence of, if necessary, a child psychologist that would assist the police officer in interviewing the child. My understanding is that that does not happen in most cases. That's the exceptional case, but most of the time the interview will be conducted by the police officers alone. The medical examination usually consists of what they call a rape kit, which would be vaginal and anal swabs, fingernail cuttings, and those things are then taken to the Forensic Sciences Center for DNA analysis, which admittedly most of the time we do not get DNA analysis because they have an issue at the lab, but it's done anyway. In relation to once the accused man is charged with a sexual offense, there's the issue of bail that comes up. Most of the time, the complainant may not be present at the court on the first appearance, which is when the magistrate will have to decide whether or not the accused man could be granted bail, which is where lawyers like you can come in. If the complainant has other representation, then that lawyer can, I would suggest, speak to the police prosecutor or the police investigator about any concerns they may have about the complainant's safety, which may affect the question of bail. Because of course the magistrate can decline to grant bail if the magistrate thinks that there's substantial grounds for believing that the accused man may interfere with witnesses, and in this case specifically the complainant. So The magistrate may consider things like the relationship between the parties, the proximity of their residences if they live apart, whether the accused man has any previous convictions, and especially convictions against the complainant specifically, whether there's any history of violence between them. And those are factors that will affect whether or not the magistrate will grant bail. If you could put up the first poll, please, Robin. So before we get into I'll discuss each of the offenses. Actually, let me go back. I'll discuss each of the offenses, but before we get there, I want to take a poll and we'll discuss this a little bit, and then we will discuss each of some of the offenses under the Sexual Offences Act. So if you can read the poll and tell us what you think would be the criminal liability for each of the persons A, B, C, and V.
For those of you who may have just joined us, we are doing a quick poll, so please feel free to read the poll and then answer as you're comfortable. And Krystal, just let me know how much longer we want to keep it open. So far, we only have...
Let me know how many responses you have.
Yeah, so far we're at 4. So we got a few more to take the poll.
How many we at now?
Sorry, we're at 9.
Okay, how many participants?
We are a total of 15. Yep. And also, I think we're at 14. So still at 9.
Okay.
If anybody else wants to go ahead and quickly enter an answer, please do so. But I think we're pretty steady here.
Actually, you're including me? I didn't answer.
No, the 14 wasn't including you.
Okay. All right, we can move on.
Okay.
All right, if anybody answered, okay, nobody for A. Anybody that answered for B, none for A, rape for B, rape for C, want to tell me why they're saying that? Why nothing for A? Nobody?
Hi, Krystal. I would say, this is Nyla.
Hi.
I would say that's a defense, but it shouldn't excuse them. They may try running that defense, but it might not work.
What
And that
defense?
shouldn't affect that they're all drunk.
Okay.
But I wouldn't I would still expect the prosecutors to proceed in charging them.
Okay. So what did you choose, A or B?
I chose C.
You chose C. Tell us why you chose C.
Because I thought that definitely B should be charged with rape. C, I thought the definition for rape was just vaginal and penile, so that that would actually fall under buggery. I wasn't sure about what A would be charged with, but I figured A is an accessory.
All right. Anybody said rape for each person?
We had, 3 people who answered.
Anybody want to say why they said rape for each person? Go ahead, Rita. Rita? Okay. All right, you can close the poll, Robin. All right. So what is rape?
Rita's saying her mic is not working, so I guess she's going to type into the chat now.
it's not working. No problem. All right, section 3 defines rape as any person who has sexual intercourse with another person without the consent of the other person, and who knows that the other person does not consent to the intercourse or is reckless as to whether the other person consents. Section 3(6) says that rape includes the introduction to any extent in circumstances where the introduction of the penis of a person into the vagina of another would be rape. A, of the penis into the anus or mouth of another. B, the introduction of an object not being part of the body into the vagina or mouth, the vagina or anus of another. So section 3(6) seems to expand the definition of rape beyond just penile penetration of the vagina. So rape now includes the introduction of the penis into the anus or mouth of another person, and also the introduction of an object not being part of the body into the vagina or anus of another person. So the introduction of an object like a dildo, for example, into the anus of another person will be classified as rape, now given the expanded definition under section 3(6). So what must be proven? In relation to the offense of rape, the prosecution has to prove that there's penetration of the vagina, mouth, or anus by a penis or an object. And the mens rea is that the accused man intended to penetrate. Also, we have to prove a lack of consent. I don't know what is missing from there. Lack of consent. And then we have to prove that the accused man intended to penetrate the vagina, mouth, or anus of the complainant. That the accused man knew, sorry, I keep saying accused man, that the accused knew that the complainant was not consenting or was reckless as to whether she was consenting, and that the accused did not reasonably believe that the complainant was consenting. In relation to penetration of the vagina, it must be noted that the vagina is not the medically defined vagina. The vagina for the purposes of law is the labia. So anything inside the outer lips of the vagina constitutes anything inside of the outer lips constitutes vagina for the purposes of law, which is important because sometimes you will have a case where the medical doctor may say that there is no medical evidence of penetration of the vagina, but for our purposes, that does not necessarily matter because the vagina in law has a much wider definition than the medical definition. And penetration is a continuing act. So sexual intercourse occurs as soon as there is the slightest degree of penetration of either the vagina, mouth, or anus. But the penetration, so sexual intercourse happens once there's the slightest degree of penetration, but penetration is a continuing act. So it doesn't stop until the penis or the object is withdrawn. So there's a case called Katamaki, and in that case, he initially thought that reasonably believed that the complainant was consenting when he first penetrated her vagina with his penis. But he subsequently, during the course of the sexual intercourse, realized that she was in fact not consenting, but he continued anyway. And he was convicted and argued on appeal that when he penetrated his vagina, that was the point in time that he believed she was consenting, and reasonably so, and therefore he could not have been found guilty for rape because the sexual intercourse happened at the point of penetration, and at that particular time is when he thought she was consenting. But the court said no, penetration is a continuing act and it continues up until the point of withdrawal, which makes sense, of course. We do not have to prove the emission of seed, so we don't have to prove that the accused ejaculated in order to prove that there was penetration. And typically we prove penetration by the evidence of the complainant. So the complainant would say the accused penetrated my vagina, my mouth, my anus with a penis or with an object, depending on what the case is. We will also have the medical evidence of the doctor, which would say, well, there was bruising, tearing, lacerations, bleeding to the vagina or the anus. And there will be forensic evidence, which is the presence of sperm in the vagina or the mouth or the anus, as the case may be. Of course, the presence of sperm does not say necessarily that there was a lack of consent. That just says that there was sexual intercourse. So if the accused man is saying that it was consensual, the presence of semen may not necessarily take you any further in proving that there was no consent. If we can have the next poll, please. Robin.
Yep, just bringing it up. For some reason, there we go.
All right, to prove consent, the prosecution must prove that the complainant fought or tried to fight off, there's a typo, off the accused, agree or disagree. Give you a couple minutes, well, a minute.
So far, we're at 9 of 14.
You could bring up the results.
Yep.
Oh, I'm glad to see this. So everybody disagrees. Unfortunately, many jurors seem to think that way, even though the judge will direct them that you don't have to prove that the complainant tried to fight off. But that used to be the law before this 1994 act. You had to prove that the sexual intercourse was by force or fear or fraud. But section 24(2) of the Sexual Offences Act, Cap 154, says that a person who does not offer actual physical resistance to intercourse shall not, by reason of that fact alone, be regarded as consenting to the sexual intercourse. And of course, that puts on a statutory footing the case of Alujoba, which is a 1982 case. And in that case, the House of Lords said that there is a difference between consent and submission. Every consent involves a submission, but it by no means means that follows that a mere submission involves consent. So the court draws a difference between submission and consent and recognizes that there will be cases where people freeze or people react differently, and not everyone is going to have that fight or flight reaction, and some persons just freeze and they submit rather than actually fight. So mere submission is not the same as consent. As you will know, consent is, of course, a full defense to rape. So if the jury finds that there was consent, the accused man has to be acquitted. If the jury finds that he reasonably believed that there was consent, then he has to be acquitted. The consent must be freely and voluntarily given. So under section 3.2, there are a number of presumptions where the law presumes that there was no consent. So if there was the application of force to the complainant or someone else, the law presumes in that situation, there was no consent. If there was threat or fear of application of force, the impersonation of the complainant's spouse, false and fraudulent representations as to the nature of the act, use of the accuser's position of authority, or intimidation of any kind, the law presumes that in those situations, there is no consent. Of course, a person can only consent if they have the capacity to consent. So in a case where a complainant is very intoxicated, the law may presume in those situations that he or she may not have the capacity to consent. And that's from the case there, Bree, which is a 2008 case. But on the flip side of that, it is no defense to rape to say that the accused was intoxicated. There's a case called McCullough from Australia, and in that case, it says, if intoxication were allowed to play an accommodating role in the context of sexual offenses, it would invite criticism that the new law would create a drunkard's rape charter. So of course, what they're saying is that if intoxication were a defense to rape, then every person would just say that he or she was drunk. in order to get off of the charge. So the law does not recognize intoxication as a defense to rape. The Crown must prove that the accuser's belief that the complainant was consenting was reasonable, and that statutory requirement actually overturns a House of Lords decision called the DPP and Morgan. And in the DPP and Morgan, the court said that the accused just must believe that the complainant was consenting. He must honestly believe that the complainant was consenting, and it was irrelevant whether or not that belief was reasonable. So in DPP and Morgan, the accused persons were officers in the Royal Air Force, and one officer who was married to the complainant was out drinking with two others, and he invited them back to his house. And he said to them that they can have sex with his wife, and that she is going to protest and she's going to fight, but she just does that to heighten her sexual arousal. And the more she fights, that means the more aroused she is. So these two other persons went back to his house and they had sex with his wife, and she fought and protested, but they continued to have sex with her. And she actually protested and fought to the point that she actually obtained injuries that she had to be hospitalized for. And the court in that case said that, overturned the convictions of the accused persons and said that they honestly believed that she was consenting based on what her husband said, regardless of whether or not that belief was a reasonably held one. So this requirement that the belief must be reasonable now overturns the decision of DPP and Morgan. So now the accused must believe that the complainant was consenting, which is a subjective, but now that belief must be a reasonable belief, which is an objective test. As I said to you earlier, section 3.2 speaks about false and fraudulent representations as to the nature of the act. And if there are false and fraudulent representations as to the nature of the act, the law presumes that there is no consent. There are a couple cases that discuss, old cases, that discuss fraud as to the nature or purpose of the act. There's a case of Flattery, it's 1877 case. In that case, the complainant had intellectual disabilities and she also suffered from epilepsy. The accused was a doctor, and he said to her that he was going to cure her epilepsy by performing surgery on her. The surgery turned out, in fact, to be sexual intercourse, and the court held that there was no consent because there was fraud as to the nature of the act. So she was consenting to surgery, she was not consenting to sexual intercourse. So in that case, no consent. In the case of Williams, a 1923 case, the accused was a singing coach and the complainant was a student of his. And he said that in order to improve her singing, she had to do a breathing exercise, and he was going to conduct the breathing exercise on her. The breathing exercise was in fact sexual intercourse, and the court said that her consent was obtained by fraud as to the nature of the act, and therefore there was no true consent. The case of Tabassum, the accused man told various complainants that he was compiling a database for breast cancer, and he had to conduct physical examinations of their breasts, to which they all consented. And they found out after that he was not, in fact, carrying out any breast cancer research. And the court said that there was no true consent, because even though they were consenting to the nature of the act, that is, they were of course consenting to a breast examination, they were not consenting to the purpose of the act. And because there was fraud as to the purpose of the act, there was no true consent. In the case of Lineker, the complainant was a prostitute, and she made an arrangement with the accused man that he would pay her £25 for sexual intercourse. And he had no intention of paying. Can you hear me, Molly? Just got a message saying that my audio quality may be affected by my internet.
You sounded good.
Okay. He had no intention of paying, and he in fact did not pay after the sexual intercourse. And she said that it was rape because he obtained her consent by fraud. The fraud being, of course, that he never intended to pay the 25 pounds. And the court said that there was true consent, and that consent was not destroyed by being induced by the appellant's false pretense that he intended to pay. They said there must be deception as to the nature of the act or the identity of the act. And in this case, she consented to intercourse, and they had intercourse, and therefore she consented to the act. All right, we can discuss consent by fraud, fraud in terms of a fraud as to identity, fraud as to, and then conditional consent. So in what circumstances can there be conditional consent? And if that is broken, then rape could be established. If you could bring up the third poll, please. All right, so which of the following do you think vitiates or negates consent? And you can choose more than one. So if the accused pretended to be male, but was really female, in that case, can you say that there was no consent to any sexual activity? If the accused pretended to be wealthy and he actually was not? If the accused lied about his name and occupation? If he lied about having a vasectomy, so he actually did not have a vasectomy and the complainant became pregnant, could that be rape? If the accused lied about his intention to withdraw before ejaculation, he never intended to, and he didn't in fact withdraw, can that be rape in those circumstances? If the accused lied about being single and he was in fact married. So in what circumstances can fraud actually vitiate consent so that sexual intercourse could be then rape in those circumstances? If we can bring in the responses, please. Robin, I'm going to turn off my my video to save the bandwidth because I got another message saying that is low quality.
No worries.
All right. So 92% of you think that if the accused pretended to be male but was in fact female, that can negate consent. If he pretended to be wealthy, well, that's very important to some people. So some people probably will think that if they were told that somebody was wealthy, he wasn't, then that should vitiate their consent, but 0% says that. Lied about name and occupation. Lied about having a vasectomy, 54%. Lied about intending to wear a condom during the intercourse and didn't, 62%. Lied about his intention to withdraw before ejaculation, 54%. Lied about being single and was in fact married, 8%. Are there any persons who responded lied about a vasectomy? Sorry, lied about intending to wear a condom, but then they didn't say lied about a vasectomy? Because I see that one is 54 and one is 62%. Any persons chose just one of those two things? All right, y'all are quite a bunch. All right, that's fine. So, fraud as to identity, you are correct that if the accused lies about being a different gender, then that can negate consent. There's a 2013 case of McNally In that case, the accused and the complainant were involved in an online relationship for about 3 years. At the time of the beginning of this online relationship, they were just 13 and 14 years old, but they thought that they were exclusive boyfriend and girlfriend in this online relationship. And during the course of the relationship, they would have phone sex. And during the phone sex, the accused would speak about what he would do with it in inverted commas. He would speak about putting it in. So shortly after the complainant turned 16, she asked to meet up with the accused. And when they met up, they had, they had oral sex, and there was also digital penetration of the complainant's vagina, digital meaning fingers. And they met up a couple times after that, and they engaged in the same sort of sexual contact. But at all times, the complainant thought that the accused was male. Somehow she found out eventually that the accused was actually a female, and a complaint was made to the police, and she was charged with assault by penetration. So the issue of consent came up. The court said this: in reality, some deceptions, such as in relation to wealth, will obviously not be sufficient to vitiate consent. Thus, while in a physical sense, the acts of assault by penetration of the vagina are the same, whether perpetrated by a male or a female, the sexual nature of the acts is, on a common sense view, different, where the complainant is deliberately deceived by the defendant into believing that the latter is male. Assuming the facts to be proved as alleged, the complainant chose to have sexual encounters with a boy, and her preference, that is, her freedom to choose whether or not to have a sexual encounter with a girl, was removed by the appellant's deception. So in that case, the court said that the fraud as to the accuser's identity, whether she was male or female, did in fact vitiate the complainant's consent. In another case of Monica and the DPP, which was a 2013 case, back in 1997, the complainant was environmental activist in a group called Reclaim the Streets. The accused, well, not the accused, but she got into a relationship with somebody she knew as Jim Sutton. Jim Sutton was in fact an undercover police officer, and after they met, they then became involved in an intimate relationship, a sexual relationship, for some months. Years after, the complainant, reading a newspaper article, realized that this Jim Sutton that she had this sexual relationship with years earlier was in fact a police officer. And she then went to the police and said that she didn't actually consent to having sex with a police officer. She consented to having sex with Jim Sutton, a fellow environmental activist, and she wanted a charge of rape to be lodged against the accused, against Jim Sutton. Well, sorry, his name was Boiling. The DPP refused to charge, and the case was actually a judicial review case of the decision of the DPP not to prosecute Jim Boiling. The court said that in this case, there was consent. They said that where to draw the lines and differentiate between deceptions which negate consent and those which do not. Whilst many would agree, for example, that deception surrounding wealth should be filtered out at the claimant stage, for the claimant's first objective stage, there can be little doubt that for many, the financial standing of a potential sexual partner is very important indeed. By contrast, few, if any, could doubt the fundamental deceit of a married person entering into a bigamous marriage, which would lead to almost all bigamists being guilty of rape or other sexual offenses. That would inevitably result in the criminalization of such conduct, which hitherto has fallen outside the embrace of the criminal law. So in this case, the court said that it was that the lie as to his identity did not actually vitiate the consent, and in this case, there was no rape. in relation to conditional consent and a promise to wear a condom, in the case of Julian Assange and the Swedish Prosecution Authority, Julian Assange being the WikiLeaks gentleman, and there was an extradition hearing for a request by Sweden to have him extradited there. And it was alleged that he had sexual intercourse without a condom, even though it was a prior arrangement between him and the complainant that a condom would be used. So the court had to decide whether there was dual criminality and whether that act could amount to rape within the laws of the UK. And the court said that in that case, the failure to use a condom when there was a prior arrangement that a condom would be used, or the accused man removing the condom in the middle of the sexual intercourse would in fact negate consent. The issue was whether a woman's consent to sexual intercourse was only on the basis that the defendant will wear a condom. And the court found that in that case, that the failure of him to wear the condom did in fact vitiate the consent, which I find interesting compared to the case of Lawrence, which is whether a lie as to a vasectomy could amount to negation of the consent. So in the case of Lawrence, the complainant and the accused had sexual intercourse, unprotected sexual intercourse. He told her that he had a vasectomy. She fell pregnant and found out that he actually had not had a vasectomy at all. And the court said that the issue was whether the appellant's lie was sufficiently closely connected to the performance of the sexual act rather than the broad circumstances surrounding it. For the reasons we have given in our view, it does not. So they found that the lie as to vasectomy was not so closely related to the sexual act that a lie about it should negate defense, should negate consent. So the court held that a lie as to fertility would not negate consent, even though that's one of the reasons for wearing a condom as well. So I kind of think is an interesting the line that they have drawn between the lie as to the wearing the condom and then the lie as to the vasectomy. There's also another case called
Krystal, just letting you know that Shane has raised his hand.
Sorry, I can't see at all. Go ahead. Because when I share the screen, it's taking up the whole screen, so I can't see anything. So you could just let me know.
Hey, Krystal.
Yes,
I was trying to square that with the conditional consent of the prostitute. Mm-hmm. She agreed to have sex with the man for money, not because she loved him or wanted to be in a relationship with him. So how is that not conditional consent as well?
I agree. Well, I guess in that case, they're saying that there was no, because the law speaks about fraud as to the nature or the purpose of the act. And they're saying, well, she consented to sexual intercourse. There was no fraud as to the nature of the act. Everybody knew it was going to be sex. And there was no fraud as to the purpose of the act. We all know the purpose of sexual intercourse, if you go to a prostitute, is for sexual gratification. So they're saying that deceit as to whether or not he was actually going to pay does not actually go to whether the purpose of the act or the nature of the act. But they're saying that these issues as to wearing the condom or a promise to withdraw actually go to the root of the sexual encounter, and therefore a lie as to that can actually vitiate consent. But interestingly enough, not a lie as to whether or not the person was had a vasectomy, because they're saying that you, with the vasectomy, in the end, you consented to unprotected sex, and that's a risk that you were willing to run, and therefore his lie did not actually vitiate the consent. It wasn't a lie as to the nature of the act because you consented to unprotected sexual intercourse, in essence. What do you think about the vasectomy? I wish I can't. figure out.
I think the same thing should go for the vasectomy as the condom, because she wanted to have, or I should say the complainant wanted to have sex, but did not want to have a child. That was at the root of her consent. So I think we're splitting hairs here. We're going to say that if you take off the condom, then that is vitiating the consent. But if you go with false pretenses saying that you have the vasectomy, when you don't, then that is not vitiating consent. That's why you don't do criminal law.
But in Lawrence, with the vasectomy, the court said, deceit and deception are very slippery concepts, which at one end of the spectrum may result from a clear short lie through more obscure utterances. I guess probably what they're trying to say is, this is what I was thinking to myself. I think what they're probably thinking is that the reality is, when it comes to relationships and sexual relationships, people lie all the time. So I guess at what point will you draw the line and say, well, this lie does not count as vitiating consent, whereas this one does?
Yeah, I understand the point that they don't, I guess for policy considerations, they don't want to criminalize all of the wrongful acts which take place in relation to sex and intercourse. I guess Correct. That's how they're trying to draw the line. I don't know if they agree though.
There was also a case, which I call fraud as the clean bill of health, a case called the Queen and B. And in that case, it was a case for rape, and it was a case for, rape. And it was discovered after the sexual intercourse that the accused man actually had HIV. And the judge, in giving direction to the jury, spoke about his HIV status as whether or not that can vitiate consent, the fact that he did not say that he was HIV positive. And the court said that his failure to disclose his HIV status was not capable of vitiating consent. So the HIV, what they're saying is that it can be an offense. It can be something like a serious bodily harm, but it would not be rape in those circumstances. If it is that she had actually consented to the intercourse, him not saying that he was HIV positive would not vitiate her consent. But they said that they declined to say whether an express lie as to his status would vitiate the consent.
That was going to be my question to you next. If prior to, she said, I want to know your HIV status, and let's say you present a fraudulent health certificate or whatever, will that then be able to vitiate consent?
I think it probably
if it turns out to be a lie.
I think it probably would if you compare it to cases like the Julian Assange and which is the promise to withdraw, the promise to use a condom. I think that would be so closely connected to the actual intercourse that they should definitely say that it would vitiate consent. But they said that they were not going to address that question at that stage. Marital rape. I've done a timeline here. So prior to 1991, the law that was that a husband could not rape his wife. The position of the law was that, first, in essence, a wife was almost property. So even if back then, if a wife was raped, it actually amounted to offense against the husband, like a property offense against the husband, and not necessarily offense against her. Also, the courts found that by virtue of the marriage contract, the wife had given irrevocable consent to intercourse with her husband, and therefore it was impossible in law for a husband to rape his wife. Then in 1991, the court turned that all upside down, and they said the idea that a wife by marriage consents in advance to her husband having sexual intercourse with her, whatever her state of health or objections, is no longer acceptable. They said that the prior to 1991, which is that a wife could not be raped by her husband, they said that that was a legal fiction. The reality is that because just by the mere fact that you're married does not mean that every time there's an advance that you wish to have sexual intercourse, and the law saying that was a fiction that could no longer be sustained. So in 1991, the court said that there could be rape within marriage. There was no need for a separation agreement or anything, just outright there could be rape in marriage. And then the 13th of February, the day before Valentine's Day, ironically, 1992, Barbados brings into force the Sexual Offences Act, Cat 154, and we seem to have taken a step back because we're in the case of the Queen and R. They said there was no need for a separation between the parties in order for a husband to be charged with rape. We then introduced Section 3(4) of Cat 154, and we say that a husband can only be charged for rape if there is a decree nisi, if there's a separation order or a separation agreement, or if there's an order for the husband not to molest his wife. So it seems to have been a step back for, I guess, wives in 1992 when we brought into force the Sexual Offences Act. It was another, my math is the worst, 1992, 2002, 10 years, 14 years? Anyhow, 20? Anyhow, it was another number of years in 2016 when the Parliament enacted the Sexual Offences Amendment Act, and they said that a husband commits rape where he has sexual intercourse with his wife without her consent by force or fear, where he knows that she does not consent or is reckless as to whether or not she consents. So in essence, it almost puts it on a statutory footing with Section 3(1). So there's no need for there to be a separation agreement or a decree nisi or anything like that. So a husband can be charged for rape. "24 years, thank you. That's my colleague helped me out because my math is terrible. So 24 years later, it only took them 24 years to realize that Section 3(4) was more than inadequate, especially, well, y'all would know better than me, y'all practice family law, but just living in Barbados, we would know that many times people separate, they go their separate ways, and it could be many, many years or decades even before they even go before the courts for a divorce. Some people just never even get divorced, they just live in separate houses. And in a situation like that, if the husband raped his wife, he could in fact not be charged for rape in those circumstances, notwithstanding that they may have been separated for 5 years or something, if they never went before the courts and got a decree nisi, a lawful separation agreement or order, or an order for him not to molest his wife, which was obviously very inadequate. So in 2016, that was amended. I just have here what I call common rape myths. These are some of the things that I bring up when I speak to my jury. People tend to think that rapes are committed in dark alleys by strangers. That is far from the case. I certainly don't have any statistics, but from what I see in my job, most of the cases that I indict and prosecute for sexual offenses are persons that are known to the complainant. There are very, very few cases where it's a complete stranger. People tend to think that a person who is raped must behave in a particular way, which is a good thing that we have the earlier section I spoke about before, which talks about consent not being the same as a submission. Because everybody, especially, you hear it a lot here, people tend to say, that could have never been me because I would have, whatever, I would have kicked him in his nuts, I would have do this, I would have do that, all kind of things people think they would do. But the reality is that none of us know what we will do unless we're faced with the particular situation. So there's no one way for someone to behave if they've been raped. Similarly, there's no definition of a rapist either. A rapist could be anybody. People tend to think if you have somebody in the dock and they look very decent, they speak well, then they probably, that's not what they have in mind when they think of a rapist. But there's no definition or picture of how a rapist should look. Some people tend to think that if the complainant went somewhere with the accused, then it probably was just sexual intercourse and not rape. Oh, but she went on a date with him. She went to the drive-in. Well, he drove in a skirt. Everybody knows if you wear a skirt, he drive in. You know where you're going for. Or she went to his house. Where she went in his house if she wasn't looking for sex. People have a lot of presumptions as it relates to that. In particular, if the complainant went somewhere with the accused, then it probably was not sex, which of course we would know is not true.
Sorry, Krystal. Nyla has.
Go ahead.
What is the average number of rape cases every year? Is it more or less common than non-sexual offenses such as mugging?
I do not have any statistics, Nyla, but to be honest, I would say it's more than you would think. Because since I started getting, because I get the vast majority of sexual offenses that come into the office come to me. And since that has been the case, I have been shocked, to be honest, at the number of sexual offenses that happen in Barbados. That's the reality. To be honest, I kind of feel like it's probably more, but I don't have any statistics. So don't quote me on that. But it's probably more than you would think. But I guess probably what happens as well is that because it's a lot, as I said, it's not a lot of stranger rape. It's people that are known to the complainants. I guess it probably does not get as much publicity as other types of offenses, but they happen a lot for sure. In recognition of the fact that lots of people have these, hold these misconceptions as it relates to rape, sorry. Even though, right, in light of the fact that most people have these misconceptions as it relates to rape, some judges actually give a direction to the jury as it relates to these presumptions. And they speak to the jury about these assumptions and say to the jury that it's important that you leave behind any sort of these assumptions and stereotypes as it relates to rape. The offense can take place in almost any circumstances between all kinds of different people who react in a variety of ways. And in the UK, I believe when they do a sexual offense case, the judge actually tells the jury this before the case starts, which I like because you kind of nip that in the bud. So they tell the jury that before the case even starts. And then again, in the judge's summation to the jury, the judge will repeat that again. Sexual intercourse with persons under the age of 14, that's contained in section 4. And it just says, oh, right, that it's an offense for somebody to have sexual intercourse with a person under the age of 14. The prosecution has to prove that there was sexual intercourse, that the complainant was under the age of 14, that the accused was not the complainant's spouse, which I find very interesting because I don't know that you can get married on a 14 anyway. And what must not be proved is consent. I didn't mention this just now actually as it relates to rape and consent. But if rape is charged, you must always prove consent, even if the person is under the age of 14 or under the age of 16. So in the case of JP Doyle, the complainant in that case was, I think, under 14. I can't remember her age, but she was definitely under 16, and the offense of rape was charged. And the judge told the jury she was 13. The judge told the jury that she could not in law consent to rape, and therefore they did not have to consider that at all. On appeal, the Court of Appeal said that that was incorrect, that consent is always a live issue when it comes to rape, and therefore, even though in law we say that a minor cannot consent, once it's Section 3, the Crown has to prove that there was no consent. So in that case, the conviction for rape was quashed and a conviction of serious indecency was imposed. But if Section 4 is charged, consent is not an issue at all. We do not have to prove consent. What I didn't say earlier as well is that a boy under the age of 14 cannot be charged with the offense of rape. There's a presumption in law that a boy under the age of 14 has not gone through puberty and he's therefore impotent. It's a very old common law presumption, and for some strange reason, we've chosen to put it on a statutory footing. And especially in today's age, we know that that is not a reality, that a boy under the age of 14 is very capable of having sexual intercourse. And under the Sexual Offences Act, a child under the age of 12 cannot be charged with any offense under the Sexual Offences Act. Whereas for other offenses, the age of criminal responsibility in Barbados is 11 under the Juvenile Offenders Act. But for the purposes of the Sexual Offences Act, it's 12. Sexual intercourse with a person between the ages of 14 and 16. That section says that if a person has intercourse with a person between the ages of 14 and 16 with her consent, it creates what we call the young man's defense in Section 5.2. So it says that if the person honestly believed that the complainant was 16 years or older, and that person was 24 years of age and had not been previously charged with a similar offense, then he can be acquitted for the offense of having sexual intercourse with a person between the ages of 14 and 16. In relation to having intercourse between two minors, I have heard of situations where two minors have sexual intercourse, the male is charged. I don't agree with that at all. I think that if two minors have sexual intercourse, that the law courts is not the place to resolve that. When the act in the UK was being debated, one of the Lord Faulkner said, our overriding concern is to protect children, not to punish them unnecessarily. Where sexual relationships between minors are not abusive, prosecuting either or both of them is highly unlikely to be in the public interest, nor would it be in the public interest of the child. And I agree. If two minors have sexual intercourse, I do not believe that that is something for which it should be criminalized, and it should not go before the law courts. There you go. All right. Yes. Sorry. So incest, I think we have another poll. Poll number 4. Go ahead, Robin. Does incest include sexual intercourse between first cousins? Yes, 80%. Okay, I was with that 80% too, some time ago, until I realized that sexual intercourse between cousins, first cousins, is actually not illegal. The Sexual Offences Act says that incest is sexual intercourse between, if a person has sexual intercourse with their parent, child, sibling, including half siblings, grandparent, grandchild, aunt, niece, or nephew, or uncle. So it actually does not include first cousins, which I was very surprised about. It only covers, Section 6, incest only covers blood relationships. So other types of familial relationships will be covered by Section 7. So it covers stepchildren, adoptive parents, persons who are guardians of children, etc. Consent is irrelevant as relates to these two charges. However, if it is that somebody engages in incest, if it's committed under duress, fear, or intimidation of any kind, that person will not be guilty of the offense of incest. If the relationship is proved, there's a rebuttable presumption that the accused knew or should have known about the relationship. So of course, too, we will prove it by either viva voce evidence of certain people, or of course, we can use documents like marriage certificates or birth certificates to prove the relationship between the persons. Indecent assault is an alternative verdict to incest, and it's also an alternative verdict to rape as well. Buggery, Section 9. Buggery is not defined in our Sexual Offences Act. It simply says that buggery is an offense. It's defined in by the common law, and buggery is sexual intercourse of per annum by a man with a man or a woman, or sexual intercourse per annum or per vaginum by a man or a woman with an animal. Consent is not a defense at all. Nor is being married. To me, buggery is almost like a strict liability offense. You just have to prove that there was sexual intercourse, there was penetration of the anus, and that is it. We don't have to prove any kind of mens rea element in terms of consent or belief that a person was consenting or anything like that. Of course, most countries have gone away from the law of buggery. I think back in the 70s for the UK, they said that they kept buggery on the books, but they said that it was not an offense between consenting persons over the age of 16. In the Caribbean, we have continued to hold on to the offense of buggery. In Belize and in Trinidad, they've had constitutional challenges to the buggery legislation. In Belize, it's actually not called buggery, but it amounts to the same thing. In Belize, it's called carnal intercourse against the order of nature. So in both Belize and Trinidad, the buggery legislation has been held to be unconstitutional. We have similar challenges in Barbados, but they have not gotten as far as a decision as yet. Bestiality is sexual intercourse per annum or per vaginum by a man or a woman with an animal. There's a case called R&DLW from the Supreme Court of Canada. And in that case, the accused man horrifically abused his children, his daughters, and he'd been found guilty of several offenses in relation to them, including counts of bestiality. The facts were that the accused man had put peanut butter on the genitals of his daughters and caused the family pet to lick it off. And he was convicted of buggery in those circumstances. But the Court of Appeal, Supreme Court of Canada said that those acts did not actually amount to buggery because you need penetration for buggery. So those offenses, those acts did not actually amount to buggery in that case. So his conviction for buggery was overturned, but he had several other offenses that he'd been convicted of. Indecent assault is covered by section 11, and it is an assault accompanied by words or circumstances indicating an indecent intention. A person under the age of 16 cannot consent to indecent assault. I said earlier that it's an alternative to rape and incest. Indecent assault does not have to be an assault touching the actual skin. It can be done through clothing. Indecent is whatever the reasonable man would think is indecent. You know, in law, we like to use about the same word to define the word. So whatever the reasonable person would think is indecent is indecent. And as I said here, you will look at all the surrounding circumstances to determine whether or not there was an indecent intention. So in the case of the Queen and K, which is a case from the House of Lords in the UK, the accused was convicted of several counts of indecent assault. He had a foot fetish, and he went around taking off the shoes of young females, and he'd been convicted of indecent assault. And the court said that it did not amount to an indecent assault because the reasonable person would not think that taking off a shoe is indecent. And whilst I said that that indecent assault is an alternative to rape and incest, interestingly enough, it is not an alternative to having sexual intercourse with a minor. I'm not sure why maybe it's because we don't have to prove consent, but it's not an alternative to that count. Serious indecency is an act, whether natural or unnatural, by a person involving the use of the genital organs for the purpose of arousing or gratifying sexual desire. So anything using the genital organs, the penis or the vagina, breast would, well, I don't know if breast would count as genital organs, probably not. So the penis or the vagina would amount to serious indecency. And very strangely, I find there's actually no issue of consent for the offense of serious indecency. And that's what the Court of Appeal of Barbados held in the case of Woodall. They said the offense does not contemplate consent, and the appellant having committed the act on or towards the complainant has been properly convicted by the jury. Which I find to be very, very strange that there will be no issue of consent, because that would mean that everybody would have been guilty of indecent assault, of serious indecency at some point in time of their lives. Since you don't have to prove consent, is not an issue. All right, having discussed that, those are all the offenses I'm going to touch under the Sexual Offences Act. There's one last issue I want to address, but we're going to do another poll, and this poll is a repeat of the first poll we did. Let's see if you changed, if anybody changed their answers. Yes, Robin. All right. So some people still saying none for A. Anybody want to discuss why they're saying no criminal liability for A? Anybody that chose that option? Why no criminal liability for A? Nothing? Anybody that said buggery for C? Why buggery?
Good
No?
evening.
Yeah, anybody?
Right. The buggery offense, that was female on female.
Yes.
So, right. So, but I asked this question because I just wanted confirmation about the act of buggery. So, a female doing that to a male will constitute buggery.
We can talk about that shortly, but right now the complainant is a female and C is a female. So
Right.
if C penetrates the complainant's anus
Yes.
with a dildo,
Right.
would that constitute buggery?
Yeah, but that does, I can maintain that position then. Yeah.
But the definition of buggery is penile penetration of the anus. So I don't think a dildo would constitute penile penetration. That would be penetration by an object.
Once a female is doing it.
Sorry?
Once a female is doing it, that being is a female and it is an object, it would not qualify as buggery.
Well, if it was a male, it wouldn't qualify either.
Okay, all right.
Because the definition of buggery is penetration of the anus by a penis. So
Okay.
I think it will be rape for each person. If this was something that I had to indict for, it would be right. It would be rape for each person, even though A does not actually engage in any intercourse. Of course, he can be charged by virtue of the joint enterprise, which we didn't discuss because that has nothing to do with sexual offenses. But he could be charged by virtue of the joint enterprise principle. And we know that penetration of the penis by a vagina is rape by the definition. But given the expanded definition in section 3.6, penetration of the anus by an object also qualifies as rape as well. So each person can actually be charged with rape. But what do you, and we're going to do it with the same poll, but we're going to change the gender of the complainant to male. If you could put up the next poll. So do you think that the answers would change depending on the gender of the complainant? So we have penetration of the anus with an object, and then we also have penile penetration. So what is the liability of those persons if the complainant is now male? If we could have the responses. So buggery for A, buggery for B, nothing for C because she's female. Rape for each person. So 56% think that it's still rape for everybody, regardless of the gender of the complainant. And 33, so a third of you say buggery for A, buggery for B, indecent assault for C. All right. So that brings us to the issue of who can rape, who can rape, and who can be raped. So in April of 2021, the Court of Appeal handed down this decision, the Commissioner of Police, Stephen Allen. In this case, the magistrate had dismissed a charge against the accused man, Stephen Allen, because the complainant was male and he had been charged for rape. And the court said that, the magistrate said that in his opinion, rape cannot be committed against a male the complainant has to be female, the accused man has to be male under Section 3. So we appealed that decision. We appeared before the Court of Appeal last year, and they handed down a decision this year, and which never happens. Each person, each law justice of appeal actually wrote a judgment. So the first judgment was Justice Chandler, and he said that his interpretation of Section 3(6) is that only females could be raped and only men can rape. So in other words, only females can be complainants of rape, and only males can be accused of rape. So he said that's his interpretation of Section 3(6). And further to that, he says that by the mere existence of Section 9, which is buggery, Parliament could not have intended Section 9 and Section 3 to coexist if Section 3 covered anal sex, because Section 9 outlaws anal sex altogether. There's no defense to it. So Parliament could not have intended to put anal sex in Section 3 again, but offer a defense to it, which is consent, which is an interesting argument. I actually will be very keen to hear what y'all have to say, because I'm going to be CCJ and I'm preparing my submissions at the moment. Justice Narayan, he said, even though, sorry, going back to Justice Chandler, so he says that men cannot be the complainants of rape at all because of the existence of buggery, even though females can be complainants of buggery. So to me, there is something wrong there. So if females could be complainants of buggery, why is it then that he's saying that by the existence of Section 9, men cannot be the complainants of anal sex under Section 3, but females can? Justice Narayan, he said that both females and males can rape and be raped. However, men cannot be raped by penile penetration of their anus. So he's saying that for the purposes of Section 3, men can only be raped by penetration of their anus by an object, or penetration of their mouth by a penis, but they cannot be raped by penetration of their anus. Interestingly enough, even though that was not what was before the court, he said that a female can rape a man by penetration of her own vagina, which was not before the court at all, but interestingly enough, that's what he said in his decision. He came to his decision by virtue of the fact that there's Section 9, and he said that it could not have been that Parliament intended to have two anal sex provisions. This is me just shortening what he said. There could not have been that Parliament intended to have two anal sex provisions in one act. And further to that, he said it's absurd that the prosecution would choose to charge for rape in circumstances where they have the offense of buggery available, and buggery would be easier to prove. Wait, hold on a second, sorry. Sorry, wait too far. Justice Bell dissented, so it was a majority decision. Justice Chandler and Narayan made up the majority, and they came to kind of different conclusions using different routes. And the same conclusion using different routes. And Justice Bell dissented and said, men can be charged for rape, women can be charged for rape, men can be complainants of rape, and females could also be complainants of rape. I would be very interested to hear what y'all think about that. Don't be shy.
Raquel, you can go ahead and unmute your mic.
Okay, well, I don't practice criminal law very much. However, I do agree with Bell, and I actually think from a perspective of jurisprudence, we are looking at a Caribbean where Section 9 is under threat from constitutional challenges. I'm aware of that. I have been involved in that movement. Maurice Tomlinson is a personal friend, and I know of his battles in Trinidad and Belize. I was actually in Trinidad. So that's the first thing. If we then interpret our law so that rape cannot cover a man being raped, and then we have a constitutional challenge that invalidates Section 9, then we will leave men unprotected when they are raped. And surely Parliament could not have intended for men to be unprotected from sexual assault. Therefore, I don't see why anal sex cannot be covered in 2 sections, because penile penetration is covered in more than 2 sections. So the idea that you can't cover it in 2 sections as a reason for not allowing someone to charge men for rape when they were in fact raped doesn't seem to me to be on any kind of sensible jurisprudential footing. I don't know what you feel about that, Ms. Delaney, but that is just how it strikes me. That simply saying you can't cover it in 2 sections so it can be rape is not really very forward thinking of the court, and is not really applying any sensible principles of jurisprudence to the matter, nor is it in looking at what's going on in the current dispensation. I think it's rather short-sighted. I would go to CCJ too.
Anybody else?
Nyla
Sap?
also says she agrees with Justice Bell.
Yeah, somebody messaged me as well and said that they think a broad interpretation should be applied versus a narrow approach, states the nature of rape is based on consent.
Excuse me,
Yes.
right, so the reason why he wasn't charged for buggery is because of the fact that is under threat constitutionally?
No, I think, well, I am not involved in the charging process. The police normally charge without, most of the time, without any input from us. But I think that they charge because of the circumstances of the case. It was anal sex without consent, and a broad interpretation, I think just a literal interpretation of Section 3(6) would mean that it covers a situation like that.
Oh, I understand now. So how we interpret buggery here is 2 consenting males who are involved in that particular sexual act. That is buggery.
No, buggery is just penile penetration, the anus, full stop. It actually is the reality is it is not imposed on consenting adults at all. But it is just penile penetration of the anus.
So my understanding of it is that if the individuals knew each other and were consenting and were engaged in that activity, that would be the charge.
It can be the charge if they knew each other or they did not know each other, which I guess is Justice Chandler's position. So if it is, buggery covers consenting anal sex, and it also covers situations where there is no consent. So Justice Narain is saying, well, why would the Crown choose to charge for buggery and have to prove additional elements of consent and lack of consent, etc., when they can simply choose buggery where you only have to prove anal sex? And it's absurd for the Crown to charge for rape when there's something easier to prove, to charge, which is what Narain is saying in essence. But what do y'all think about, Henry picking y'all brains now, but what do y'all think about Justice Chandler's argument, which is that if Parliament has wanted to outlaw anal sex altogether, so they've created Section 9 without a defense to it, could they really have intended then to put the same actus reus in Section 3, this time offering a defense to it, which is consent and reasonable belief in consent? What do y'all think about that?
I don't think that the intent of Parliament with respect to that buggery provision was what you were you're developing as an argument, because that buggery provision, as far as I'm concerned, has to do with the act in and of itself between two males, and a society that does not tolerate that kind of behavior. This is my perspective. It has nothing to do with rape, as far as I'm concerned, where that is concerned. So having a defense there was never the issue, as far as I could see from Parliament's perspective. If you wanted to show that a man could be raped in the manner as prescribed in Section 3, then you should have provided for that. What we have here is a situation where the statute does not, as it is constructed, does not lend itself to dealing with that. And if it's silent on that, I can't see how a justice could stretch it. I've heard somebody comment and say that is too narrow an interpretation, but once you start to cross that line, I mean, in terms of what is narrow, and it's not even mentioned there, where you can stop with respect to that aspect of it. I don't know. I thought it would have been easier. I thought it would have been easier, and I agree. It would have been easier to have. It would have been easier to have charged the buggery, and prove that, than it would be not to open this kind of worms under that rape section.
I just carried it back to Section 3.6, which is a section that case concerns. Section 3.6, rape includes the introduction to any extent in circumstances where the introduction of the penis of a person to the vagina of another would be rape. A, of the penis into the anus or mouth of another. B, the introduction of an object not being part of the body into the vagina or mouth of another. So Section 3.6 doesn't speak about male or female, he, she, it just says person and another. Don't you think then that Section 3.6 is broad enough to cover men as complainants and women as accused persons?
I don't have the act in front of me. My next question to you is another defined within the confines of this particular piece of legislation? That would be my question to you.
It is not, but the word person is defined in the Interpretation Act, which predates this act. And Interpretation Act says that person, for the purposes of any enactment, person includes, I think it says person includes male and female, but the definition says male and female for sure.
With respect, I can't see that's a stretch. You mentioned, Ms. Delaney, you just mentioned the Interpretation Act with respect to definition of a person. Does it say anything about another in the Interpretation Act?
No, it does not.
Okay, all right.
Yeah, Raquel. Yes, please, Raquel. Raquel? I see your hand up. Mic unmuted, but I can't hear. Shane?
I agree with your interpretation, Krystal. I think the legislation is wide enough to cover both a male and or female complainant. The legislation is gender neutral, and it gives the prosecutor an opportunity to charge under both sections. You can charge under the 3.6 for the rape, or you can charge under the buggery. Yes, it may be true that it may have been easier to go under the buggery section, but it can equally go under the 3.6. I will have to read the judgment of Justice Chandler before I shoot off my mouth saying I fully disagree. But based on what you have presented to us, I think the legislation is wide enough for the charge to be brought under that section.
I certainly think so, which is why I'm appealing.
There are also a few comments in the chat. I don't know. Yeah. Would you like me to read them out or? Okay, so I'll go straight back to the top. So Michelle Gibson says, this raises issues of whether this legislation is discriminatory or on its face based on gender. The purpose of the act broadly is to prevent offenses against persons, not just a single gender. The sections of the legislation should be construed widely or together and given a broad interpretation. And then we go on to talking about, Kimberly says, is person in the Interpretation Act, which we just discussed. Chanel Brathwaite says, to me, the legislation is gender neutral. Kimberly goes on to say, I think it is wrongly excluding the definition in the Interpretation Act of person to think that person in this SOA does not include male. And Krystal says, I think I have to read the case, but now looking back at the section, I think it is wide enough, so I take back what I said. And Kimberly ends with, even if it's easier to charge for buggery.
Okay.
And we have a few people with their hands raised.
Chanel?
Now that I'm looking at the two sections, so section 9 for buggery and section 3, I think they have two different purposes. I think Jactor was alluding to it earlier. I think the intention behind the section 9 in relation to buggery was, I guess, a reflection of society's, I don't want to say disdain, but disapproval of that type of act. Whereas, so that's just in general, so there's no issue as to consent. That's the reason why there's no issue as to consent. Whereas with section 3, I think that the purpose behind that was to protect or to punish against non-consensual acts. So I think that there are two different purposes behind these two different sections.
Which I agree with, but what Justice Chandler is saying, which is the biggest hurdle, admittedly, that I think I have to cross, is what he's saying is if Parliament intended by Section 9 to outlaw homosexual acts, because that's the reality of it, then wouldn't Section 3 be in essence bringing it through the allowing it through the back door? That's his argument. But I agree with, I can't remember who made the comment, but in terms of the discrimination, that's one of the arguments that I intend to make. It's extremely discriminatory and it does not offer males the same protection under the law, because if a male, based on Justice Chandler's interpretation of Section 3, if somebody penetrates a male's anus with an object, right? So in our example, we had a dildo. Then let's start with female. If somebody penetrates a female's anus with an object, then that person can be charged with rape, and the penalty for rape is life imprisonment. If that person does the same act to a male, the charge would have to be indecent assault, and the penalty is a mere 5 years. The exact same act committed on a male and a female. So life imprisonment versus 5 years imprisonment.
And
So
also,
pardon?
and also, I wanted to say that with buggery, both of them are guilty, no? Or only the one doing the penetrating?
Could you repeat, please?
Because I was thinking that with buggery, both persons who engage in act
will be guilty of buggery, correct? If it's consensual, of course, because if it's by force, then the person who is committed on would not be guilty of buggery. But yes.
Okay, because I'm saying, because now we are having a situation where you can be raped and be charged for buggery.
No, right, so you wouldn't be charged if it wasn't consensual.
Okay, because I don't see it, as you were saying before, it seemed to be a crime of straight liability. So I don't see where in that section it says if it was forced on you, you are not guilty.
That is not in the section, because the section simply says it's an offense but the law, it would not criminalize some person. The same way how I told you with the incest, if a person commits the act by under duress, fear, or intimidation or force, they will not be guilty of incest. Similarly with Section 9. But I will keep, I'm sure that the maybe it will go to the bar once the decision is back, because the hearing is not until November, so we may not have a decision until next year. So the state of the law right now is that a male cannot be a complainant of rape by the majority court, in this case, Commissioner of Police and Stephen Allen. So that's the state of the law as it is right now. We will see what the CCJ has to say about it in a few months. We just have a few more minutes, so I can just sail through these. Possession of pornography. This is in relation to possession of child pornography. We have the Protection of Children Act and the Computer Misuse Act, which talk about publishing, producing, possessing, distributing child pornography. And child pornography and indecent photograph is the same sort of definition. Anything that a reasonable person would think is indecent. A child is under the age of 18, which is interesting because the Sexual Offences Act says you can have sex at 16. So, but for the purposes of child pornography, under the age of 18 will constitute child pornography. Malicious communication, Section 14, if an offense is an offense to send a message, letter, electronic communication that is indecent or obscene, and that is an offense under the Computer Misuse Act, but it's only a summary offense. What is not covered by the legislation, and in my opinion should be, is an offense of grooming. Especially, I think that we should have an offense of grooming in Barbados. In Australia, they define grooming as predatory conduct undertaken to prepare a child for sexual activity at a later time. I believe there are some cases that even say that there don't even have to be sexual conversations at the time, but if that's the development of a relationship, it's grooming. And I think this is very important because I actually see a lot of cases, sexual offenses cases, that start on social media. So the relationships start on social media, Facebook and Instagram. So the sort of conversations that these persons are having, because I actually had one case where we had the WhatsApp conversations between the accused and the complainant. And the sort of conversations that they're having, I'm thinking to myself, should be an offense because it's clear grooming. But based on the law now as it stands, it's not actually an offense until the two parties meet up and some sort of sexual activity occurs. Arranging to meet a child for sexual activity, sexual communications with children. They're all kind of similar. This one I feel should really be an offense: abuse of positions of trust or offenses by care workers. We don't actually have any in our legislation offenses committed by care workers, and I think that that's desperately needed in our legislation as well. Causing a child to watch a sexual act or like pornography, I think that should be an offense as well, because lots of grooming begins that way. Well, not really begins, it begins with just talk and stuff, but before they actually get to the sexual contact, there's a lot of the time we have showing each child pornography and certain things like that. Creation of a sexual offenders register, I definitely think we should have that. We don't have it. I've never heard any discussion about having it, so I don't know if that is a plan. And we do not have any specific legislation as it relates to FGM, which is female genital mutilation. It would be covered, I figure, by something like a serious bodily harm, but we don't actually have legislation specific to that. These are things that we pretty much should know as attorneys. So under the Sexual Offences Act, provision can be made for the evidence to be taken in camera, which is in chambers. The complainant cannot be identified in the press. It's actually a criminal offense. When we ask the complainant questions in examination in chief, we can only ask open questions or non-leading questions. And we can only ask questions in the re-examination that are limited to matters which arose in cross-examination or which need clarification. And we can only ask open questions in re-examination as well. Cross-examination of the complainant, what I will speak to is section 26 specifically of the Sexual Offences Act, which speaks about questions to do with the sexual history of the complainant. When I'm prosecuting, we have persons try to do this a lot. Ask questions. I actually had a poll, but we're not going to bother with that given the time. But ask questions about if the person was a virgin at the time, or ask questions about their sexual history. And based on section 26, most of that, if not, well, most of that, those sort of questions would be inadmissible because the sexual history is limited to sexual contact around the time of the commission of the alleged offense. And of course, as in all cases, the questions must be relevant to the facts in issue. Evidence by minors, the court must conduct a voir dire if you have a child to determine whether or not the child should give sworn evidence. Section 31 sets out the test, and it's also in section 15 of the Evidence Act. If the court believes that the child should not give sworn evidence, the child is still allowed to give evidence, but they have to say, I promise to tell the truth. But if the child does not give sworn evidence, the accused cannot be convicted unless there's corroboration of the child's evidence. We recently got in 2020, I think somebody's mic is on. We recently got in 2020 a practice direction on special measures. It's not specifically to do with sexual offenses specifically, but it's to do with vulnerable witnesses, and most persons would accept that the complainants of sexual cases are vulnerable witnesses. And it says that if a witness is eligible for assistance, if the court is satisfied that the quality of the evidence given by the witness is likely to be diminished by reason of fear or distress on the part of the witness in connection with testifying. The only special measures that they speak about in this practice direction are live link, giving evidence in private, which I assume just means in camera, use of an intermediary, and use of communication aids. Especially with children, the use of communication aids may be very useful because that may include things like anatomical dolls. Use of an intermediary, they have that here, but I don't actually think that, right, yeah, sorry. So the intermediary the questions will be asked to the intermediary, and the intermediary would relay the questions to the complainant, and similarly, the answers to the question would also come through the intermediary. There are a number of considerations that the court has to take into account in deciding whether or not a witness is, one, vulnerable, and two, should be given special measures to allow the witness to give their evidence. I think it's probably a mistake, but interestingly enough, in the portion of the practice direction that speaks about giving evidence in private, it says that all persons have to be excluded from the court except the accused, which made sense, of course, the legal representatives, which made sense, and an interpreter, but it doesn't actually say the jury. So of course we would know that has to be some sort of mistake because you cannot excuse the jury from a criminal trial. And what I just wanted to say here as well is that even though we have taken steps towards giving assistance to vulnerable witnesses, I don't think we've gone far enough. In some jurisdictions, the accused man, if he's representing himself, is not allowed to ask the complainant questions. In some cases in the UK, if you have very young children, they don't even allow you to ask questions. When the witness is interviewed, that is video recorded, and certain questions may be put then through the intermediary, and the witness's evidence is played in the trial, and no questions are actually asked at that stage, and the jury just has the benefit of the video recorded evidence of the complainant in order to make their decision. I spoke about corroboration in relation to children, but Section 28 generally says that no corroboration is necessary for sexual offenses, which used to be the case. But a jury should be warned that it may be dangerous to convict the accused in circumstances where there's no corroboration. So on the one hand, you're giving us something. So you're saying, oh, no, we don't need corroboration, but the next time you're taking it back. So yeah, you don't need corroboration, but it may be dangerous to convict if there's no corroboration. We have a two-stage test in the decision to prosecute in our office, and it is firstly an evidential test. Is there enough evidence to provide a realistic prospect of success? And we look at the evidence, taking into account, one, whether or not the evidence that we have is admissible evidence, how a jury is likely to look at the evidence, whether the evidence is reliable, whether the evidence tends to be persuasive. We also then have a public interest test, whether it is in the public interest that the case be prosecuted. Of course, with sexual offenses, well, with most sexual offenses, it would be in the public's interest that the case be prosecuted. Unless, as I said earlier, if you have two minors who have consensual intercourse between themselves, then it will not be in the public interest that be prosecuted. That's probably the only thing I can think about. Outside of that, it will probably always be in the public interest that the case be prosecuted. Unless, of course, the complainant does not wish to proceed. It will ever hardly be that we compel a complainant to give evidence against their wishes. If they do not wish to proceed with the case, we will speak to them about it. But if they do not wish to proceed with the case, that's their decision to make. In sentencing the accused, the court will take into account aggravating and mitigating factors. These are just some of the common aggravating factors in sexual offenses. If the accused did not use a condom, if he ejaculated, if the offense carried on over a long period of time, or there were commission of multiple offenses. So for example, if there was a rape by penile penetration of both the mouth, the vagina, and the anus, for example. If there is use of violence, threats, or a weapon, if it was premeditated, if he has previous convictions, if there's abuse of trust or authority. So if it's like a teacher or somebody at church or somebody in a position of authority or trust. If the complainant is vulnerable by virtue of for example, age or disability. And age, of course, would be young, like children, and then it would also be old, elderly people as well. If the accused has a high risk of reoffending, if he acted in concert with others, and if there was predatory sexual behavior. Common mitigating factors: a guilty plea, no previous convictions, remorse, cooperation with the police, and the age of the accused. So if he's quite young himself, that will be mitigating as well. I think that's the last slide. That's the last slide. Any questions or comments before we leave the meeting?
I had a query.
Yes.
Krystal, you had said earlier that you think Barbados should implement a sex offenders registry. I know in the Caribbean, I think Jamaica has a closed registry. And last year, Trinidad amended to have an open registry. I think other than Trinidad, the main proponent of the open registry is the US. Is it the open registry that you're proposing or the closed one? Where it is that it is, I think the closed one is where like schools and stuff can request the information. But to me, the closed one seems just like a normal police certificate character. Or the open one Trinidad is going for.
I didn't say they recommend that is going to happen. You know, I said I think they should.
I know, yeah, you think which one do you think is more likely to actually occur in Barbados? Because I know the argument is always made in small islands, an open registry may be very challenging. Right. In terms of persons ever finding somewhere to live. The challenges that occur in the US by a million times more in a smaller society. But Trinidad is
have to live on the bridge.
Yes, or in the swamps in Florida. But in Trinidad last year, because I think one of those cases that was really horrific last year, they amended to do the open registry concept, where everybody can access and see if you've been convicted of anything under the schedule.
I don't know. I haven't given it that much thought to see what kind of registry they should implement. I think that it's probably not going to happen. I have never heard really any reform in relation to sexual offenses. The only thing I've heard recently is in relation to the creation of a sexual offenses court in Barbados, where they will hear only sexual offenses in that court. It will be set up physically in a way that will be conducive to that. The prosecutor will be trained, the judge will be trained, but I haven't heard any other possible changes to the act, including a register. I haven't heard anything about it. So I don't have any idea what they will do, if anything. Okay. But I wanted to hear your opinion in relation to Stephen Allen and whether a male could be raped.
I strongly strong. I imagine that decision is going to be overturned. I can't see how a modern thinking of how we view gender and sex and not considering any sex to be weaker or the stronger sex. I can't see how we will continue that thinking. Or if they don't amend the decision, if they don't reverse the decision, they're going to amend legislation.
That means CCJ will amend the legislation?
No. I mean, if it is that the decision itself is not reversed by the CCJ, I can't see how our parliament will not take the initiative then to amend the legislation. Right. If we're in a society now that we see women and men as being equal, and it's not that just women are the weaker sex to be protected, but that our men and young boys also are in the same light.
It was answered the question about who can examine the complainant of a rape, if it has to be the public medical officer. I do not believe, to my knowledge, it does not have to be the public medical officer. Most of the time it is, but I don't think that there's anything statutory that says it has to be the public medical officer.
Hi, Krystal and Marsha. Thank you for a very informative session. Just a flag, I know we had a session at the UN a couple of years ago where the doctors in the accident and emergency, the head of the accident and emergency at the time, did raise that same question about who examines a rape victim. And she was actually saying that, yes, according to the law, only the police doctor is supposed to do the examination, and they were asking for that to be struck, because what happens sometimes is that she says women will come to the hospital, they will present, and they don't say right off the bat that they were raped. But in doing the examination, they recognize, obviously they're doctors, so they're seeing, what makes them ask further questions. And then she says they have to stop at that point and call in the doctor. So sometimes it results in a person, being examined more than once in a circumstance where you're dealing with rape. And she was also making the point that if the act is amended and expanded, nurse practitioners, as happens in other parts of the world, could take some of the burden off the doctors here and probably offer a service that's more gender specific, because a lot of nurses are women and so are victims of rape, unfortunately.
I'm not familiar with exactly what legislation that will be that says it has to be the PMO. I am not sure. I have to research that to see. But I totally agree. I think that we should move towards, they call them scene nurses in the US, sexual assault nurse examiners. I think we should definitely move towards having scene nurses conduct the examination for persons who have been raped.
I think that would raise a question about the reason why I asked about that with respect to the custody, the evidence, and who ultimately has responsibility for harvesting it and securing it and then presenting it at trial and making sure that it is secure from the point of view of being fair to the accused.
In relation to whoever does it, in relation to whoever does the Wait, just 1 second. I'm trying to figure out how to mute myself. I can't find that. Sorry, in relation to the whoever does it, they will obviously put certain things in place as it relates to the chain of custody for the exhibits. So even if a general practitioner does it, the police will be there, not obviously not in the examination room, but the police will be there and they will take the exhibits, whether it be the clippings or the smears, etc. The doctor will write their initials on them, hand them to the police in a exhibit bag, and then the police will then take that and carry it to the Forensic Sciences Center, which is our lab, and then they would have their chain of custody documents there as well. So even if the person went to a GP, I wouldn't see that the chain of custody should necessarily be an issue once they just continue to do what they've been doing. All right, there being no further questions, that's the end of the lecture. Thank you so much for having me.
Thank you so much, Krystal. I think, yes, that concludes all of the questions for this evening. Thank you so much, everyone, again, for joining us this evening. We look forward to seeing you on Thursday. Again, it was with our two U.S. divorce and separation, high conflict divorce and separation specialists. And if you have any questions in the meantime, and again, any questions on Krystal's presentation that you would like to ask or outside of this, please feel free to email us at operationsafespace.bb@gmail.com. Thank you so much, everyone. Have a good evening.